as possible. Please use the Q&A box as the comment section is comment box has been disabled for this event. On this note, I will invite Yomi Olugbero, our West African tax leader, to give us the opening remarks and formally open the session. Over to you, Yomi.
Thank you so much, Ada. And good morning, ladies and gentlemen. Thank you so much for joining us this morning for this important webinar. I'm indeed very delighted to have everyone join us for this important conversation. Like Ada said, this conversation today, it's about the Nigerian Customs Service Act, the new law, the new Customs Service Act 2023. And we have themed it, navigating the new trading landscape, because we think this new law actually make, some fundamental changes into, how trade, is facilitated in the country. As most of you on the call will know, this new law now, it's about 6 months old. It was passed into law in 2023 and replacing the original legislation that we've all come to know. That law was a 1959 Act. And so it was a law that we've all related with. I'm referring to the Customs and Excise Management Act, CEMA, that had been the bedrock of the legal framework, for trade facilitation in the country. So it's 6 months, and because of the significant changes and the fact that it's a whole sweep replacement, of an existing law, it's generated quite a lot of interest among all of the stakeholders, businesses, regulators, trade experts, third-party logistic service provider, and everyone that has something to do with import, and export and trade in general. So quite a lot of conversation is going on. It's new, even though we think it's 6 months, and so it's appropriate for us to have as much conversation as possible about it so that we can understand what the key provisions are, we understand what the compliance obligations are, and then if there are gray areas or issues, we can begin to, tackle them. So that's essentially why this conversation, it's organized today. It's a much long-awaited, refresh, of the law, as it were, and we're happy that we have everyone, joining us this morning to have the conversation. If you've, looked through the law, of had interaction with the law, you will know that the changes are quite significant, touching, quite different areas, including, very significant penalties for various infractions, and non-compliance, okay, including even the custom authorities itself, now exposed to one form of, penalty or the other. But we also have provisions within the law that provides guidelines on, how do you handle dispute, how do you, handle appeal, how do you appeal the decision if you're unhappy with rulings or position taken, by the service, right? And also quite a lot of new, introduction, as it were, from our own climb, the introduction of the new authorized economic operator scheme, which is a global best practice that we've seen around the world. We now have it within the framework of our law. So all of this important conversation is what we intend to touch on, right? And because of this development, we think everyone, and on both sides, both on the side of the regulator and on the side of the business community, that we get acquainted with the provisions, we discuss it, we hear the perspective of the service, we hear what concerns or issues that the market is raising on some of the legislative provisions. So that's why we have this conversation on this side today. So I'm trusting that through this conversation today, we'll be able to achieve that aim, that everyone, particularly our clients that are on the call, will be armed with the information and tool they require to evaluate the impact of this new law, on their operations and the compliance obligations that it places on them, and general awareness for everyone. This is going to be one in several series. I'm aware also that the service had also done, quite a lot, in trying to push out awareness about the law, and we're happy to have them on board today to also share some of the perspective they've pushed into the market and hear directly from us. Of course, like Ada said, this is a 2-hour conversation, so we know that it's maybe difficult or not practical to touch all of the amendments, and all of the provisions. So we'll try to focus on the key issues. But in addition to the conversations we will have today, there is a trade newsletter that Deloitte had already prepared, which provide a lot more expansive review on the law. We will share that newsletter with all of our participants on the call so that we can read more and we can get a lot more acquainted. So but for today, you can be sure that the expert we have on the team representing trade players, the regulator, and also our colleagues from my colleagues who will provide their own insight, will help to shape this conversation and ensure that we all enjoy the session. I want to especially thank the panelists, particularly. I know that by the time you are being introduced, you will be appropriately recognized and thanked, but let me in advance thank you for offering your time to be part of this session, and essentially appreciate everyone who joined this conversation today for being part of the session. So let's all have an active engagement. Let's put our Q&A in the box like Ada had said, and I'm hoping that we will be able to touch as many of them as possible. On that note, I would say it's my absolute pleasure to welcome you to this Deloitte Pleasure webinar, and to say have a wonderful and enlightening session today. Thank you so very much for being part of it. Ada, you can take it off from here.
Yeah, thank you so much, Yomi, for that opening remark, which has now set the tone for set the context for the discussions we want to have today. We're about to proceed to the presentation by the Nigeria Customs Service. Please remember, the Q&A box is open. Use it for your questions and your comments, and we will go on. Without further ado, I would introduce Ms. Uchenna Ugolum. She is an assistant legal advisor with the Nigerian Customs Service, and her team has been actively involved in sensitizing the public on the provisions of the Nigerian Customs Service Act 2023. She's here to share insights with us, and we would listen to her now, for her presentation. Ms. Uchenna, over to you.
Hello, Ada. Good morning, everybody. Thank you for the kind introduction. So I'll just give a brief background and overview of the Act. I know that the time is a bit short, so I'll see what I can do within my time frame. So the content of my presentation is background, the difference between the old and the new law, an analysis of the Nigerian Customs Service Act 2023, then a conclusion. As Mr. Yomi said, the Customs and Excise Management Act was enacted in 1958. This is obviously a very long time. And since then, there's been a lot of improvements in economy, population, technology, but the Custom and Excise law remained unchanged, definitely needing to come up in line with existing realities. On 20th April 2023, the Nigerian Customs Service Act was signed into law by former President Muhammad Buhari, and it has been officially gazetted. So what this new law aims to do is it wants to revamp the service, which would in turn increase revenue and boost operational and administrative work. Now, let's take the difference between the old and the new law. The SEMA had 13 parts, 195 sections, 3 schedules, and 19 subsidiary legislations. The Nigerian Customs Service Act, on the other hand, has 33 parts, 282 sections, 1 schedule, And all of the legislation, all of the regulations that were in the old SEMA have been consolidated now into this new act. Obviously, the changes that are introduced into the new act will meet up with the existing realities of present-day operations of the service. Now, the act has provided for stiffer punishments, that's in terms of fines, and increased prison terms. Establishment of the service. This is the beginning part of the act. Sorry, excuse me. The first thing that the act does is that it confers legal status on the service. Previously, the service could not be sued directly. If you had to sue the service, you would have had to go through the board. But now, if you take a look at sections 2B of the new act, it has conferred legal rights and responsibilities on the service, which then means that the service can sue and be sued. If you also take a look at the functions and the powers of the service, these are now directly assigned to the service as opposed to the board, which was what was previously obtainable in the SEMA. Section 5 of the new law provides the powers that the service can exercise, but this is of course subject to the board's approval. One of the key responsibilities of the board in the act is the formulation of general policy guidelines and regulations for the service. The rationale behind this provision is that it gives the service the flexibility to meet up with, the changing roles of everyday actions. Because if you codify things into the act as it is, then to be able to change it, you would have to go through the full legislative process. So this provision was put into the law to be able to give the service the flexibility to make regulations and guidelines, etc., in line with existing realities. Now, if you take a look at the governing board, the act establishes the management committee of the service and their functions. This is in part 4. And then the board membership has been streamlined to include relevant stakeholders. And also it would interest you to note that there are 2 representatives from the private sector with a term of 4 years that is renewable for another term of 4 years. That is section 7. The supervisory role of the Minister of Finance, Budget and National Planning has also been reinforced in this act. And it is pertinent to state at this point that consultations would be had by the minister with the Controller General of Customs before he issues directives. We can take a look at section 12 of the act for this. Now, a very novel provision in this act is the appointment of the Controller General of Customs from a career officer not below the rank of ACG. Previously, anybody could become the Controller General of Customs, but now the act has stipulated or generally provided for the appointment of the CGC to be from a career officer within the service. Finance. This is also one of the major innovations in the act. 7% cost of collection used to be what was used to calculate the finance for the Nigerian Customs Service. But now a minimum of 4% of the free on board value of imports has been introduced. The president has the authority to adjust this 4% FOB. We can take a look at sections 18.2 of the act. Also relating to finances, the tariff regime that is used by the board requires approval by the National Assembly, and it has been stipulated that this has to be made public either in the tariff handbook or on the Nigerian Customs Service website. This is provided for in section 18.5 of the act. The account of the service is also subject to be audited by the Auditor General for the Federation, section 22. Information. One of the things that the new act has done is that it has mandated for transparent activities of the service. This is in line with the Freedom of Information Act and presidential agenda on the ease of doing business. Information on customs processes are now to be made publicly available, but the onus to provide this information does not just lie on the service. Anybody that is also involved, either directly or indirectly, in customs formalities are mandated to provide information. The Act also provides for electronic data processing as the primary method for exchanging data between the service and people that interact with them. But of course, taking into consideration the climate that we live in and the fact that there are loopholes sometimes in accessing electronic information, the Act has also provided for paper methods to be used in lieu in circumstances where the electronic processing methods cannot be readily accessed. This is provided for in Section 25 of the Act. The Act has also mandated that put an obligation on the service to protect confidential information that it obtains in the course of its interactions. And then there's also interagency collaboration, which is promoted by the Act. This is provided for in Section 28. Now, customs controls. Customs ports, airports, and wharves are now termed as customs service controls under this new Act. There are several administrative procedures that were not codified in the former Act that have now been put into the new Nigerian Customs Service Act. These are things such as risk management mechanism, joint inspection, post-clearance audits, and joint border operation. These things were previously being done, but they were not codified in the Act and have now been provided for. When it comes to risk management, the Act stipulates that the service will maintain a risk register and risk management data, but this is bound to be confidential. There's a high penalty for violation of confidentiality of information, 5 million naira or imprisonment for 5 years or both, actually, if you're found liable on conviction. Also, the Act has provided for electronic data exchange, single window, which is something I know that a lot of people have been advocating for. And now in the Act, it is provided for there. We can take a look at Section 33 of the Act. The Act also encourages cooperations with other customs administrations in other countries, but this has to be done through mutual service agreements, because obviously the rights and obligations of the different countries have to be legally stated. Then consultants can be hired for advice on custom control issues, but they are just there for advice. They would not execute the custom control measures. Also, and I know this is like a hotly debated issue, is the issue of document retention. A look at Section 43 of the Act shows that the provisions are now clear. Documents that are shared between the service and its stakeholders are supposed to be retained for a period of 10 years from the occurrence of that event. But then in the case of appeals, a person is mandated to keep any documents relating to that appeal for 3 years after the appeal has been resolved. Then there's also the issue of the CGC, where they are issuing special service fees where someone requests for the service to do things that are outside of its normal duties. Oops, sorry, my screen is not moving. Okay. Yes, so now we come to the imports and exports procedures. The service has now modernized the repealed SEMA sections. If you look at the provisions of the SEMA sections 12 to section 80s, the procedures that were formerly provided for have now been modernized in the new Act. The penalties that are increased, like I said, have been like really high. If we take a look at, sorry, I'm just trying to pull up something. If you take a look at things like the timeline for uncleared goods, which was previously served with a penalty of 400 naira, the penalty now is like 1 million naira. So you can see that in line with the existing realities, that penalties have now been increased. Also, obligations. The Act places reporting obligations on importers or their agents. They have to report all importations and exportations. Section 46 of the Act provides for that. The Act now also embraces electronic transmission mediums to align with 21st century standards. Section 47(3) provides for that. Then, as it relates to prohibited items, the president has the power to put items under prohibition. But if we look at section 55, we can see that if subsequent approvals are also sought, he also has the power to permit someone to import or export things that are in that prohibition list. I'd already spoken about uncleared goods. This is blocking my view. Yes. So custom duties, declaration accuracy. Declarants are mandated to ensure truthful and accurate entries to prevent contravening the Act. This is provided for in section 67 of the Act. We can also look at delayed duty determination. Under the Act, where there is a delay in determining the duty for a person, the Act now permits the service to allow the person to take delivery of those goods, but this is on the condition that they provide a guarantee. Section 75 of the Act provides for this. Then also, if we take a look at section 77, the service reserves the right to investigate and ascertain the truthfulness of any statement, document, or declaration that has been presented for customs valuation. Customs debt. The Act now provides for joint liability. So in circumstances where several people are responsible for a customs debt, they will now be held jointly and severally liable under the Act. This is in section 86. The service has been mandated to notify a person of a customs debt within a 14-day time frame after the debt has been determined. The customs debt payment window is 30 days, but this is also open to extensions. The service has a 7-year window to notify a debtor of a customs debt, but this is with several exceptions. Exceptions such as where there's a criminal matter going on in the case, and also where there is an appeal. Now let's move on to guarantees and securities. There are mandatory guarantees that people such as custom licensed agents, etc., compulsorily need to provide a guarantee to the service. But also, a person can provide an optional guarantee to the service if they want expedited processing for their consideration for expedited processing of their goods. Custom representatives. Business engagements with the service is no longer just with licensed agents. Any person can engage in business transactions with the service. This is provided for sections 103 of the Act. But it is tried to note that if a person, because as you can see, the Act has already provided for engagement with business engagements with the service to be beyond licensed agents. So therefore, in section 10610, if a person illegally represents themselves as an agent, they will be subject to hefty fines and high prison terms if found culpable. Section 10610. Now let's talk about a new innovation in the Act, which is the inclusion of the authorized economic operators. The Act provides for authorized economic operators in sections 108, and the requirements to apply to become an authorized economic operator is set out in section 111 of the Act. One of the advantages of becoming an authorized economic operator is that the service offers simplified procedures to authorized economic operators. We can look at section 109 of the Act for that. Then customs procedures. There are appropriate steps to lodging particular types of declarations with the service, and this has been provided for in section 113. Also, simplified declaration has been introduced into the Act to be able to speed up trade processes and to improve revenue collection. Declarations under the simplified procedure can be adjusted. It's not cast in iron. This Act gives room for the submission of additional particulars for declarations lodged under this procedure. Release of goods. The service is empowered by Section 1191 of the Act, but subject to a court order to sell, dispose, or destroy goods in certain cases. You can find these cases enumerated in Section 119 sub A to E. But it is tried to note that if these goods have been abandoned, that the service will not bear the cost of the disposal or the destruction. It is the importer or holder of the goods that will bear same. Warehousing. There are new provisions as to warehousing, contrary to the provisions of Sections 82 of SEMA. The new Act now stipulates that both the warehouse and the warehouse keeper must be licensed. You can take a look at Section 112 of the Act. And also the Act has provided measures for the service to retain control over public and private customs warehouses. There's also punishments for where compliance is not adhered to, and also where goods are deposited contrary to any directions of the service. The warehouse keeper is liable to a fine of 3 million naira. So it goes back to that point of saying that the Act has now increased fines in reality, in line with modern day reality. There are also general offenses relating to warehousing, and you can see that the fines range from 5 million naira to 25 million naira, and imprisonment for a term of up to 10 years or both. You can look at Sections 133 for that. Now, free trade zone. It is tried to note that while it is the Nigerian Export Processing Zone Authority and the Oil Gas Free Zone that are the administrative authority responsible for granting of permits and licenses to operate in the free trade zone, the service has the duty to supervise and control the entry and exit into the zone, as well as the movement of persons, goods, and means of transport. This is provided for in Section 1342. The service has to collaborate with these administrative authorities, and then they have to deal with issues regarding examination, unstuffing, value addition, processing, and manufacturing operations in the free zone. This means that the service works with NEBSA to issue regulations. If you take a look at Section 134(6) of the Act, you will see that it provides any person who contravenes the provisions of this section pertaining to special economic zone procedure or the implementing regulations commits an offense and is liable to a fine of 40 million naira or imprisonment for a term of 5 years or both. So this is not, so you might get the 40 million naira, you might get the prison term for 5 years, or you might pay the 40 million naira and still go to prison for a term of 5 years. That's what that Act, that part means. Then let's look at the temporary admission procedure. Under this procedure, goods intended for re-export may be admitted into the customs territory with total or partial relief from duties or fees. The purpose of this importation means that it doesn't have to be for rent or resale, but for a certain defined project. So that means that if you're bringing that good in, it's for a specific purpose, and once that purpose is done, that good is going to be re-exported back outside of the country. These permits are usually restricted to oil rigs, barges, aircraft, and special equipments of high value. The Act provides circumstances where admission may be granted. You can take a look at Sections 142 for those circumstances, but it also sets the maximum period during which those goods that are under the TIP procedure to be 12 months. And provisions have also been made for extensions. That's an additional 6 months with an extra additional 6 months. Then, if we take a look at the last decade, there has been massive reduction in paper transactions, advancements in the digital space and information technology. So it has made it imperative that e-commerce transactions be inserted into the Act. This is one of the new innovations that is there. So Section 157 provides for express shipments. We'd also like to note that there's further recognition and promotion of adherence to the guidelines of the World Customs Organization in the Act. We can take a look at sections 162 for that. Export procedure and coastwise goods. Like I said earlier, there's stiffer punishments for that. For improper exports, where duty is chargeable, a fine of 3 million naira or 2 times the value of goods, whichever is greater, is what a person found liable is bound to pay. Also, where false declaration of goods to be exported is made, the penalty on conviction is imprisonment for a term of 5 years without an option of fine. Can take a look at sections 152C for that. The Act also mandates that custom duties that are collected must be remitted to the Federation account. And there's the fine of 20 million naira or imprisonment for a term of at least 5 years, or both if a person is found liable on conviction. Then the Act now provides for duty-free shops and travelers, section 162. There's also the introduction of dual channel system. The dual channel system simply means a simplified customs control system, allowing travelers on arrival to make a declaration by choosing between 2 types of channels. One channel, identified by green symbols, is for the use of travelers carrying goods in quantities of value not exceeding those admissible duties free, and which are not subject to import prohibitions or restrictions. And the other red symbol is for other travelers. This is typically what we would see in the Western world, and it has now been introduced into the Act. Also, travelers should note that they can be subjected to personal check if there's a reason to suspect smuggling or other offenses. The Act, of course, provides that this check goes from less intrusive to more intrusive. So it just depends on the level of suspicion, depending on the circumstance. It is also to be carried out by the same gender, except in exceptional circumstances where there's maybe an immediate threat to an officer or public safety. We can take a look at sections 164 for that. The Act also introduces the use of credit card payments to reduce cash handling and corruption allegation. Personal effects is now defined in the Act. This is all articles, new or unused, which a traveler may reasonably require for personal use during a journey, taking into account all the circumstances of the journey, but excluding any goods imported or exported for commercial purposes as determined by regulations. Section 165(6) further states examples of items that can be deemed personal effects. Before this inclusion into the Act, passengers were allowed to carry unused personal effects not exceeding a value of 50,000 naira. Now, we must take into consideration that at the time that the law was promulgated, 50,000 naira would have been a lot of money, but obviously, in consideration of present day, 50,000 naira really amounts to nothing. So what has been included into the Act now is that there would be a the determinant would be set by regulations. And this then means that the service will set the limits in consonance with the changing economic situations. Now, intellectual property rights. The service collaborates with the Nigerian Copyright Commission to enforce intellectual property rights. We know that it is not every agency that can be at the borders, and also that interagency cooperation is one of the main elements that the Act establishes. The service has the power to detain, arrest, or seize importations or exportations that infringe on the Copyright Act. But when this is done, then it will be handed over to the Copyright Commission, and then they will take over from there. Now, custom excise duties. This has been provided for in section 169 through 173 of the Act. A little bit of current affairs. I'm sure we all know that the president has suspended the 5% excise tax on telecom services. He has also signed the Customs Excise and Tariff Variation Amendment Order 2023, shifting the commencement date of tax changes from March 27, 2023 to 1st August 2023. He has also ordered the suspension of the newly introduced green tax on single-use plastics, including plastic containers and bottles. The purpose of all these orders are to ameliorate the negative impact of tax adjustments on businesses and chokehold on households across affected sectors. Sorry, excuse me. There are no major differences in this section between the provisions of the SEMA and the new Act, but some notable provisions include section 170, which contains provisions for the imposition of excise duties. Then section 171, which talks about the application of the 10% penalty for failure to pay excise when due. There's also section 172, which contains provisions as to the amount of excise duty to be paid. This is generally simple mathematics and it's fair. Now, the Act introduces stiffer penalties and fines for offenses contravening the following provision. We can look at manufacture of spirits. There are a lot of improvements to the provisions in the SEMA, but I have put an example there, is that for instance, if a person violates the regulations for the regulations that pertain to the manufacturing of spirits, they will be liable upon conviction for 2 million naira. This is as opposed to what was obtainable in SEMA, that was just double the excise duty. Section 182.2 of the Act also provides for a fine upon conviction of 1 million naira or imprisonment of 6 months and the forfeiture of the spirits if you contravene the regulation on the manufacturing of spirits. Also, we can take a look at manufacture of beer. A person who is found guilty of contravening this provision would pay 20 million naira or imprisonment for a term of 5 years or both, and the goods would also be forfeited. If you take a look at what was obtainable in the SEMA, the penalty was just 200 naira. Then tobacco, manufacture of tobacco and its substitutes. The Act provides for a penalty upon conviction of 20 million naira or 5 years imprisonment or both for the violation of regulations pertaining to the manufacturing of tobacco. In the SEMA, the fine was just 400 naira and forfeiture of the goods. Manufacture of carbonated drinks. This is a new innovation in the Act. The Act now provides for the licensing requirements and duty on production of carbonated drinks. A person cannot manufacture carbonated drinks and other beverages without an excise license, and failure to comply with this license results in a 20 million naira penalty upon conviction or 5 years imprisonment or both, and the goods would also be forfeited. There are similar penalties for also failing to comply with regulations. But you might wish to note that it is the Minister of Finance, Budget and National Planning that makes the above stated regulations. There's also manufacture of goods subject to excise tax. The NCA provides for stiffer penalties as well. And then as it comes to general provisions relating to excise licenses, it's also the same thing. It is just stiffer penalties. But in that circumstance, you can see that every director and principal officer of a corporate body shall be held personally liable. Take a look at sections 2145 of the Act. Now, enforcement and legal proceedings. Majority of the provisions in this this act are similar to the repealed SEMA. Like I said, major changes just include increased penalties, more imprisonment years, and incorporation of fines along with imprisonment. The act has also introduced administrative and concession settlements. Section 222 provides for that. And there's also the power to detain or search, which was also present in the SEMA, but the penalty has been increased. But Section 248 is an important introduction into the Act because it now permits for consideration for owners of means of conveyance that was used for custom offenses and it was without their knowledge. Those items would then not be subject to forfeiture if it is proved that the owner had no idea of that. Now, I'll just conclude. Obviously, it's a very short time. It's a very big act, like 200 and something provisions. So this analysis is by no means exhaustive, but I hope I have at least been able to provide some insights into the act and its innovations compared to the SEMA. The act is not perfect. It is while it is being implemented, that will be the true test of the law's effectiveness. So amendments will obviously likely be made when we have this feedback from everybody else. Thank you very much.
Thank you so much, Ms. Uchenna. Thank you for that stellar presentation. I am sure we have learned plenty from the presentation, and I'm sure that the Q&A box is teeming with questions and comments from the House. Next up, we will be moving to the panel session, where we would have conversations and have question and answer with seasoned professionals who are here to share from their wealth of knowledge and experience with us. Remember, the Q&A box is open. Please use it. Put in your questions. There will be a Q&A session immediately after the panel session where we will take questions from the House. So the panel session will be moderated by Chijioke Odo. We're moderated by Chijioke Odo, our West Africa Global Trade Advisory Lead. And I will hand over to Chijioke at this time. Thank you.
Thank you. Thank you, Ada. Ladies and gentlemen, we have come to the part where we try to get practical insights into some of the changes introduced by the NCSA. To help us unpack the changes are four distinguished personalities with deep knowledge and several years of experience in the Nigerian trading environment. In no order they are. Nancy Wanze. Nancy is the head of trade compliance for Africa Diageo PLC. She's an accomplished professional with over 12 years of experience working across a breadth of roles with a focus on regulatory compliance and advisory, international trade, business development, taxation, strategic communications, and policy development. Nancy is well-versed in cross-border trade activities, trade finance, and technology. Nancy, welcome. Second will be Mr. Segun Ajayi-Kadir. Segun is the Director General of the Manufacturers Association of Nigeria. He holds a Master's of Science degree in International Relations from Obafemi Awolowo University and a Bachelor of Science degree in Political Science from Ahmadu Bello University. He's an alumnus of the National Institute of Policy and Strategic Studies and a member of the Institute of Directors. He's also the co-secretary of the Pan-African Manufacturers Association and serves on various federal government committees, councils, and boards. Third, welcome, Mr. Ajayi-Kadir. Next up will be Ms. Maureen Adiboa. Maureen is the country manager at DHL Global Forwarding Nigeria. She has about 2 decades of industry experience across management, operations, and commercial transactions. Maureen is a lawyer and a consummate sales professional inspired by innovation and the ability to energize others with a genuine passion to win. Welcome, Maureen. And then lastly, but not the least, Mr. Smart Akonde. Smart is the Director of Legal Services at the Nigerian Customs Service. He's a lawyer with several years of experience in private and public practice. He was at various times Special Assistant to the Solicitor General of the Federation and legal advisor to several federal government agencies before assuming his present position at the Nigerian Customs Service. SMART is a recipient of many awards. I'm not sure SMART is here now, but in SMART absence, I mean, it'd be nice to have Ms. Uchenna Ighodun to sit in for Mr. Konde, pending when he comes. Otherwise, we will continue with the panel session. Okay. Ladies and gentlemen, welcome again. And thank you, Ms. Ighodun, for such a wonderful presentation. Like you said, the act is a very big one, and we can go on and on unpacking it for several hours. But we have a very short period of time. So let's see if some of the dialogue that we will have will help to unpack some other issues around the act. So I think I will start with Nancy, and I think it's helpful to hear from some of us what our general assessments of this new legislation is. So I think Nancy, I think for you, what's your general assessment? Is it what you expected after several years of debates? We've seen how it has gone back and forth, to repeal this over 60-year legislation. What specific rule changes do you think will benefit businesses? What is still missing? How does the new legislation compare to similar legislations in other African countries in which you have some level of oversight?
Okay, thanks Chijoke for having me, and thanks everyone for having me. So for the Nigerian Customs Service Act 2023,
Nancy,
so welcome.
thank you. Audio?
Can you hear me? Can you hear me?
Yes. Yes, I can
Okay.
hear.
All right. So the Nigerian Customs Service Act is a welcome development. If considering all the challenges we've had, I don't know if you have the experience engaging with the Nigerian Customs Service, where we always have to refer to the SEMA 1958. Then we had the SETAS 2004. So where the SEMA 1958 wasn't covered, then we go to the SETA 2004. So having this new law is very helpful. It shows that the Nigerian customs is now progressive and meeting up with evolution, technology evolution, a lot of things happening. Good welcome development, for example, the AEO. Very interesting. It's happening in other African countries, so happy that Nigeria is doing that. Then also the refund processes, the fact you can now give a bond. I can remember when you have issues in a couple of years ago, when you have an issue or a challenge with the Nigerian customs, you are forced to pay the duty, and for you to get the refund is a nightmare. So now you have the bonds, which is very interesting now to help businesses at least continue transacting whilst you're addressing the challenge. Another good thing is the advanced ruling. I know it's a new development, yes, but it's something we still need a lot. Yes, there's an SOP, but we still need a lot of clarity, a lot of gray area where we need the Nigerian customs to provide clarification. And again, Uchenna has said clearly, as we start the implementation, we'll start highlighting where the issues are, where the challenges are. For example, another interesting part is communication. We want electronic communications. How many people have access to NICEs? What's the platform we're going to use to communicate? It's very important to us. So these are conversations where I believe in implementing the laws, the subsidiary legislations or the regulations should provide this information. When you ask me what is missing, I won't say there is something more missing, but what I would say is there are areas where we need more clarity from the Nigerian customs. I know China tried to take us through everything. For example, the AEO section 109 subsection 3 says they'll still come out with clarity on how it will work. So yes, there are information there, but they are quite vague. So we need more clarity. What would I benefit? Even the dispute resolution process, there are 4 stages. For example, I know that normally the Nigerian Customs Service will say a WTO ruling is persuasive. So is it now binding? There's a lot of clarity we need. What's the time frame? I need to go through the service the command. What if I've had problems in my career where we are challenging a refund and the command is not aligned? So if the command is not aligned, what's other response do I have? What can I do? So there's just a lot of things where we need clarity. Yes, it's very good. It's a welcome development, but there are areas where we need clarity. And to answer your last question again, when you're talking about what is needed, like Uchenna has said, we need proper communication, advocacy. We need to let everyone know what's in the act. So seeing things today on alcohol products, there are even things on excise, which a lot of people don't know, how the excise is calculated, which Uchenna did not cover. So there are a lot of things where traders, merchants need more clarity, a lot of communication, because we've had this act for six months, and sometimes you have to go back to refer to it. So what has changed? And even within the customs officer, some people are still referring to the 1958 Act. Up until last week, when you're talking to them, they say, no, but September 1958, I need to tell them, no, there's a 2003. So even within the customs organization, the customs need to get their officers well informed about the act, about the provisions of the act. So a lot of sensitization is needed for us to understand, and clarity when they're making the subsidiary legislation. I think a comprehensive engagement framework should be implemented, because now you're implementing, you start seeing where there are areas for improvement. Now need to talk to the merchants. How can we craft this subsidiary legislation, the regulations to enable us to implement the law effectively? So that's all from me. Yeah.
Excellent, Nancy. I mean, just spoken like one who looks after quite a number of regions in Africa. I think I also like to hear from Mr. Segun Ajayi-Kadri. Same question. I mean, you're DG for lots of manufacturers. When you speak to manufacturers these days, they'll tell you one of their issues is how they move cross-border movement of goods, and some of their challenges with customs. So now we have a new legislation. Does this address some of the issues or concerns that come to your table every day? So what's your general assessment of the NCSA? Over to you, sir.
Okay, yes, thank you very much for having me. I think the previous speaker is also from the manufacturing angle. At least I used to know how to be in that space. So, and I wouldn't bother to repeat some of the things you said. But why we really still have issues with this act was because of the way it came. You know, we were all expecting that we are still going to have a public hearing at the level of the Senate, but we only just heard that it was passed because the organized private sector of Nigeria, which is comprised of MAN, NECA, NASIMA, NASI, and NASMI, we had made submissions ready for consideration at the Senate public hearing, which we expected, and even made as such to the presidency to be considered by way of looking at the act again. But as it turned out, we didn't have another public hearing at the Senate. Remember that the bill suffered some rejection from the presidency for a long period of time. But yes, here we are, we have the law now, and I appreciate the presentation by the legal officer from Customs. He has really highlighted the number of sections that ordinarily would have bothered us. And I believe, like the previous speaker said, we needed more enlightenment about what these are, and the regulations that will follow should probably give more clarity and maybe address those concerns that we still had, but were never taken into consideration before the law was, the thing was signed into law. Having said that, there are quite a number of issues that manufacturers contend with. And in terms of the capacity for us to export outside of Nigeria, it is yet to be seen how the subsequent regulations would allow us to ease that process. The ease of doing business has remained a challenge for manufacturers. Even exporting products is almost as difficult as importing them. But they say when we implement the act and we collaborate with customs, because we do collaborate with them, we'll see how we are going to address those issues. If I may just speak to some specific sections that really bothered us, and the legal officer will probably be here to give some clarity or indicate whether we have to wait for when the regulations are out. I'm sure the procedure for amending laws in Nigeria could be very cumbersome and could take a very long time. I mean, that was why we put a lot of effort. So probably the regulation might help to meet some of those challenges that we have. For instance, we are a bit worried about the removal of the right of administrative appeal to review by an administrative authority that is higher than or independent of customs, because we do believe that this is global best practice. And I was wondering whether the legal officer, for instance, will have an explanation as to how this could be taken into consideration. Also, the sections 170, 171, 172, 173, and 200, which has to do with placing products under excise tax that is payable, and also the imposition of excise that is payable. I was wondering whether this is not a fiscal policy issue, and whether it will not amount to usurping the powers of the Minister of Finance or of that ministry to operate solely in that area, as we see happening around the world. And also there is the issue of valuation appeal, the procedure for it, whether there will be appeal without penalties. I think she needed to give some clarity on that. Also, we have seen, for instance, that the governing board of customs, yes, there's provision for 2 members of the private sector, but we are wondering, because man obviously is one of the greatest stakeholders in the customs, and we have been on that board before it was recognized and clearly stated. I'm just wondering what will have informed the removal, and it formed part of the organized private sector input as to what it is, because it is now possible, for instance, to get other private sector groups, which is left to the discretion of customs to introduce just any private sector organization. And we worry about the stakeholding of the average manufacturer. We have, for instance, more than 2,500 members who operate in 10 sectors and 74 subsectors. All of them effectively affected by virtually all the items in the tariff book. I believe that holds a lot of significance in terms of determining those that should serve on the board. And we believe that the role of the Minister of Finance, for instance, now Minister of Finance and Coordinating Minister for the Economy, it is important that it is left more in authority in terms of determining customs service, because that is the place, for instance, that we have a convergence at the Tariff Technical Committee, for instance, which is under the Ministry of Finance. We have a convergence of interministerial groups that are represented there, and the private sector is also there. So if customs is acting more independent of the ministry, it may give a tendency of not being able to have the right hearing under the customs. I also want to make general comments. I believe that if a law is passed without the satisfactory inclusion of the opinion of major stakeholders, as we have seen in the organized private sector of Nigeria, which I mentioned, I believe that post-passage, there should be a deliberate and direct consultations with them, so that those issues that were not taken on board and which is made known to virtually everyone that is connected, the customs itself, the presidency, the National Assembly, and so on. A deliberate attempt should be made to meet with those stakeholders, because they are those that will, together with customs, implement the act, so to say. We are going to be at the receiving end of most of those issues. And like you rightly said when you were asking me the question, the manufacturing sector is probably the greatest employer of labor after government. And there's need for us to recognize the parlous performance that the operating environment has imposed on it. So I think in terms of regulation,
Thank you so much, Mr. Ajayi Kadri. I know that I've had conversations with you a number of times and with the Manufacturing Association of Nigeria, and there's always this back and forth between MAN and customs, and you raised quite significant issues there. I think I just want to pick on the last one, which is the role of customs, which is, yes, revenue collection, but also trade facilitation. And I think at the end of the day, that is what we would also all like to see. But to piggyback on that last point, I'd like to go to Maureen and ask her. I know she's in that logistics space, and trade facilitation is one thing that you have those conversations with some of your clients, those who move those products around. From an AU perspective, okay, authorized economic operator, we have seen the NCSA introduce the AEO. And globally, the whole essence of the AEO is to ensure that compliant traders can move. I think from that perspective, my question to you will be that as the NCSA provides for that AEO scheme, okay, consider the attendant issues faced by traders when clearing goods from the ports. Okay, what impact do you think the AEO provisions would have on the trading landscape, and more specifically businesses in your industry?
Okay, thank you so very much for having me and then that question. For me, I think it's a laudable decision from the NCSA because it's actually going to ease a lot of things, but a lot of things also have to be put into consideration. Very interesting part of the act, and I give kudos to NCS for this. We see. For me, as far as I'm concerned, we have what we call a fast track. The AEO for me should be another fast track 2.0 if care is not taken. But we're going to look at it and then see how it goes off and then what happens, especially for custom simplification. It is very critical game changer for the big manufacturers in Nigeria, be honest, because of the complexities that they go through a lot. But one key thing for me is a lot of times we encounter shipment of traders who are the beneficiaries of fast track, and it will be sitting at the port for one reason or the other, either being delayed or not delayed for administrative procedures and stuff. But once we introduce this AEO, once this is implemented, it will support those importers in making valuable inputs to the need of the manufacturer's processing. The key to success of this program for me, if I have to elaborate it, is the IT system. Customs will have EDI, electronic data interchange. If we have that for players like DHL example, I'll use DHL for instance, we have developed that. All we need now is to have that interchange with customs system. If you have that interchange with customs system, everything goes direct. They have direct access to customs server and everything. And at whatever level of visibility that customs wants it, they will have it. When we talk about ease of trade, that is what comes in here. But what we are doing presently is actually strangulating the manufacturers, wasting time because of the bureaucratic nature of course, the people we see at the port. It will help if we have this electronic EDI interchange. It will help the auditing processes, especially with the critical success. It's going to be a critical success program for whatever customs wants to do. I'll give a typical example for countries that do that. In South Africa, it is done in South Africa, Mauritius, and every other places. Even currently in Ghana, DHL is actually partnering with customs for electronically transmitted declaration. All declarations have gone in there. What does that mean? At the end of the day, it is also going to support the information the customs that they need. All the information customs need will be in there. You don't need to ask an importer or an exporter to go and get all the documentation when those things are already they're already fed into the system. So custom will have actual access for that. All the freight forwarder market, as far as I'm concerned, we believe that if it will help us to modernize what we are doing presently in Nigeria. We have acknowledged it has been tough to modernize Nigeria or the industries here in Nigeria. But once we start granting access to all these people, we find out that every other person will follow suit. It will force everybody to have a very robust technology platform as well, because that's the only thing that will help us. So the AEO for me is the way to go. That is the first step. Then once we have this, we'll now go back to customs to say, well, we need that EDI solution. Because it is available. A lot of big players like us have all of it there. The only thing we're asking customs is to grant us access. So we can feed directly into the customs system, and it is visible to everybody. Manufacturers will be happy, customs will be happy, government will be happy, and that's it. When we come up, well, it's going to curb corruption, actually. I don't want to use the word corruption, but it's going to curb all the excesses out there. Everything goes directly into the customs system, and then we'll see a lot of things change. That is from my own perspective on that.
Excellent. Thank you. Thank you so much, Maureen. I think the responses from Nancy, Segun, Maureen have been consistent, really. It's around, look, yes, it's good, it's great. You know, we've changed legislation, we have brought legislation in line with current realities, but there's still quite a number of things we need to do. And I'll go to you, Chenna. You've heard everyone, well, not everyone, because I'm sure those participants still have lots of questions and already coming through already. But is this feedback you've heard? Is it new? I know you have done quite a number of stakeholder conversation sessions with a number of stakeholders. What has been the general feedback? Is there something else that has come through that hasn't been said already? And what is your view around the legislation as well? And then, of course, if you can touch on some of the points that have been raised by co-panelists, I think it will be helpful.
Okay. Yeah, thank you, Chidoke, very much for the question. So first of all, I'd like to say that prior to this act being promulgated, there were several stakeholder engagements with both government and non-government actors. We all understand that there's a legislative process to passing of the law. So it is not at the insistence of the service that a law can be passed. It's not just, oh, if we like the provisions or not. There is a process to it. And I think one of the speakers had even mentioned that there was a problem with signing the law, with signing the bill into law, because it was because of all the different objections that went back and forth. Like I had mentioned in my conclusion, we have to understand that there's no such thing as a perfect law. So I know that this is what they say about people. It's like, oh, they say, oh, my feet is cold. And then you give a person socks and they're like, oh, why didn't you give me shoes? We are progressing slowly, but surely. The old law was promulgated in 1958. This is a very significant improvement to what was in existence. And I feel that as we engage in fora such as this, as we have stakeholder consultations, conversations, discourses, then the issues will come up that would lead to an amendment of the existing law. And we also see that there are provisions for regulations, which is supposed to cover these issues that come up now. Talking about the feedback and saying if it's new or otherwise, the sensitization at the moment, which I think Nancy, also the first speaker, had mentioned, started internally because, like they say, charity begins at home. So the sensitization actually started with our officers because we're trying to get them acquainted with the law to enable efficient operations of their mandates. I would go to some of the issues that was raised. There was quite a lot, so I was trying my best to see if I could take notes, but I would just point out on the ones that I could see. So if we can take a look, someone talked about the calculation of excise duty. Section 172 of the Act actually provides for that. So taking a look at that would clarify the issues. Then Mr. Shegun, I think, spoke about the right of appeal. Let me take you to section 270 of the law. So after the internal process have already gone on, the appellant has the right to go to court. And we know that at the end of the day, a court of competent jurisdiction is actually the best arbiter of issues, because even if you take a decision from the service to an external body, nothing is as binding as a court order. So if you are dissatisfied with the appeal process, if you look at section 270D, it provides for you to go take that decision to a court of competent jurisdiction, which I believe is always the best resort at the end of the day. I think there was also talk about the position of the Minister of Finance, Budget and National Planning and the supervisory position over the service. Section 12 already provides for this, and I think that I would actually read that out to make it clear. It says that in the exercise of the powers and the duties conferred upon the board shall be subject to the authority, direction, and control of the minister, and any written direction, order, or instruction given by him after consultation with the Comptroller General shall be carried out by the board. If you also look at section 72A, you see that the chairman of the board is the Minister of Finance. So definitely, like I said in my presentation earlier, the supervisory role of the Minister/Ministry of Finance is further reinforced in this act. Then we also we spoke about the mandates of the service. I'm happy that you guys said it. Revenue collection is not just the sole mandates of the service. The service actually has 3 mandates: revenue collection, trade facilitation, and prevention of smuggling. It is just, I think, because we are in a climate that the Nigerian Customs Service is one of the highest revenue earners, so that's always put at the forerunner of issues. But the other 2 facets are also adequately attended to, but I think maybe not as publicized. But hopefully, with the implementation of this new law and the new innovations, trade facilitation would also become really at the forefront of things. There was talk, I think, about refunds, and I'd like to point us to section 39(2) of the Act. It now provides specifically for refunds of duties that were mistakenly or inadvertently paid. This was, of course, not obtainable in the old law, so it has now been stipulated for here. Generally, like I said, it's implementation. It's the real life test of the law that would prove what is effective and what is not. There will obviously be constraints, but I think everyone is going to do their best to see that the economic climate is just going to be more favorable. Thank you.
Thank you. Uche, I know there are lots of questions. I think there's still some points that also you haven't touched on, and I can already see some questions already coming through. And one of them is on digitization. So maybe you want to put that in your notes as well, because I'll come back.
What did you say?
Digitization.
Digitization.
Yes. So electronic exchange of information.
Digitization. I can speak on. If you don't mind.
We can come back to that. So we can take other questions. But I know Maureen talked about that, so maybe we can come back to that. But I also want to touch on the issue of because I think Shegun talked about it, and I think you provided a response to it. So let me go to Nancy. Because I know Nancy in some of conversations I've had earlier, we talked about, okay, I have an issue, I want to appeal. What's the appeal process? Okay, so you can see that the NCSA talks about, and I think she also mentioned earlier on around how you can appeal. So you can lodge an appeal to the command responsible, and then from there you go to the CG, and from the CG you can escalate to the WCO, and then lastly you can lodge an appeal with the court lodge with the courts. Okay. So, but again, from your experience, because I know you also look after quite a number of territories in Africa. So, liaising with the service in Nigeria and liaising with the service in other African countries, what is the difference? Is there any consistency? And I'm talking about the NCSC now versus the extant laws in other African countries. Is it different? Is it different? Is it the same? So that we can also learn from what is happening in other countries and see if we are more optimal or less optimal than other countries. Nancy?
So I believe the NCS Act is a new development, as in it's improving compared to previously when we were operating the SEMA 1958. Comparing it to what happens in other countries, even though there's a 4-step appeal process where you go to the board, you complain, then you take it step by step, you go to the WCO, then you now go to court if you don't get the 4th stage which they give for you to appeal. Then the command, like I earlier mentioned, we still need clarity because the appeal process in the law, yes, is now clearer than it was in the SEMA 1958, but it still needs a lot of clarity because constantly, or till today, I have constant issues, even 6 months after the act was passed, that is still at the discretion of the command. So you have an issue, maybe when the law changed, let me give an example. When the law changed and we were supposed to implement the new law, then there was a suspension of the law by the president. And after which, before NICES was changed, that's the trade window, we paid guilty. And we came and said, okay, we want a refund. And because at that point, the law was not effective. And the question you get is, oh no, we are not applying for it, or it's our discretion, we don't believe it. Yes, that was what was prevailing, which we believe that there was a communication lag. The merchant or the manufacturer should not pay for that. So till today, this is 6 months after the law has been passed. The law has outlined how it would be, the issue will be addressed, but till today, it's not being done. It's still using the old method where it's at the discretion of the command. The command would say, yeah, I have to, and don't forget this time bar. So you have 1 year to lodge your complaint. If not, if you need a refund or you need to appeal for something, there's a time frame which you need to lodge the complaint. But because it still sits at the discretion, so at what point do I leave the command? Because the command, you need to write to the command. The command needs to forward your complaint to the headquarters. Then they now start the investigation. So that's still the process. So with what we are seeing now, where we may need clarity from the Nigerian Customs Service now, in the event the command is not agreeing with me, what do I do? Do I go directly to the headquarters? What's the next step if they're not agreeing with me? That's one. Comparing to other countries, I think we are coming up. We still need more structure compared to what happens in Kenya, which is a bit more structured, where if you don't agree, you go to the TAT, it's more structured, or also in South Africa, where you can ask for a tariff determination. It's more structured. So yes, we've changed the law, which is good, which is a welcome development. But we need proper clarity in the subsidiary legislation, because it's also stated in the law there will be a subsidiary legislation. So we need clarity step by step. If I have, problems differ. So you could have a classification problem, you could have a valuation problem, you could have a duty challenge, just different challenges. You could need a refund. How do I do this step by step? So if the command doesn't agree with me, what's my next point? Don't forget, even going to WCO is at the discretion of the customs. Don't forget. And in Nigeria, under the Nigerian law, a WCO ruling is persuasive, not binding. So even if we go that route, what comfort do I have in the process? I still think that there's still more work to be done in breaking down everything, breaking it step by step. What do we do? What do we need to do if there's a problem? There's been a lot of progress. The NCSA the 2023 is a very new development, good development, making progress, which we acknowledge, and we applaud the Nigerian Customs for it. But we still need more clarity. And I still maintain we still need a lot of sensitization with the command, because, with the command, because this is 6 months down the line, we still have the issues that we were having with the old act. So this is something we believe the command can, or the Customs Service can collaborate with industry, manufacturers association, private sector, still collaborate with us. Let's have more sensitizations. After this law has been passed, I've just heard about one sensitization, if anybody, that was publicly done, because there are different sectors where dissecting over 280 sections of the law. I don't think one sensitization is enough. You need to do different sensitization for different aspects, different sections of the law. So it's a welcome development. As in, I would repeat myself, very good, but we still need breakdown, we still need proper guidance. Yeah, we can still, the Nigerian Customs can look at, I'm happy that the law allows them to collaborate with other jurisdictions. So they can look at what is happening in Kenya, in South Africa, how can we tweak our subsidiary legislations, but all the same, it's good progress.
Absolutely, absolutely, it's good progress. I like how you landed there. And I think we can continue to make progress. It's just that in the current economic business climate, people want instantaneous relief because things are biting, and so we want to get to the destination promised land very quickly. And I will tap Mr. Jai Kadri now to come in now. One of the things that the NCSA has done is to significantly increase penalties for infractions. So if you speak with the officers in customs, they'll say one of the reasons why some of their actions and approaches is the way it is because traders are not complying, and some of those traders might be some of your members, and so they said, okay, let us increase the penalties. I mean, so that when we find an infraction, it's not 200 naira or 1,000 naira that a member has to pay. At that point, it now becomes more beneficial to not to comply, not to comply. So now we have seen significant increase in penalties. I mean, the penalties are right across the entire legislation. And of course, they'll say, the aim is to align the penal provisions with current economic realities. So in your view, we are where we are now. We have legislation and we are law abiding, your members are law abiding. So now we have this. What should your members do differently, okay, in view of the new legislation?
Well, thank you. Specifically about the penalties, I mean, the law is what it is. And one will agree with the officer from Customs that, yes, we needed to align even the penalties and the fees with current realities. But the current reality is based on who is making the case. For the business operator, what is reality now will be different, but the law, like you said, is the way it is. Now, I think there are issues about how the increased penalties will affect the stakeholders. On the side of customs, it then may create a situation where they want to hurry to penalty so that they will rake in more money. On the side of the operator, it then means that you have to be more careful, you have to be more diligent, you have to be more obedient, and you have to be more compliant. So, I mean, that's the way it plays out. But generally speaking, I believe that manufacturers will try, just like every other economic player, to avoid those penalties. But I think what is then more useful is for us to avoid having to apply those penalties and to see the structures that will be put in place to facilitate the absence of penalty. Because I'm sure we should all agree that in some cases, the reason why you are penalized is not necessarily due to your own fault. There could be delays on the part of customs. For instance, I heard when she mentioned an issue about uncleared goods, the extension of the days. And I was wondering if the reason why you are not able to clear is not yours. If it has to do with the deficient infrastructure, which we face every day at the port, sometimes the forklift is not working, the officers responsible is not allowed. There are so many things that could delay the clearing of your goods. Would that be taken into consideration when you are going to pay those fines? And that is what I say. I don't think, in essence, anybody who is law-abiding should worry about what the penalty is. But you could inadvertently, or you could be stampeded into making a mistake or into committing an error or being time-barred, and then you will have to pay for the consequences. I believe that what is important is for customs and the stakeholders, particularly manufacturers, to work towards a situation where paying penalties in itself is avoided. I mean, the improvement in technology, which she emphasized on, which we are very well pleased with, it will remove discretion, it will remove the use of discretion. It will also ensure that there is certainty about what you get, so long as you fulfill your own side of the bargain. But I mean, as a manufacturer, and with the introduction of what one of the speakers mentioned at Fast Track 2.0, I think it is a welcome development. We'll look forward to engaging customs more intimately, because we have a very good relationship with customs, and the current Controller General worked effectively with us even in his career path. So I believe that we should be able to have a conversation that should take us far away from penalties. I mean, because it is not good to add any further burden. It will not be helpful to the economy to add any further burden in form of penalties for any manufacturer who is law-abiding and is concerned with just getting his business done.
So, sir, if I just a quick question there, in addition to what you said. So, it might not be the fault of the manufacturer. So would you, because the law provides for what you call post-clearance audits, would you, with manufacturer, your members prefer a situation where, which is what we have anyway, so it's not a preference, where goods are allowed to move very quickly, okay, without interventions, okay, so let the goods go, and then, the customs comes thereafter to do, post-clearance audits. So in that case, your members know that, okay, I need to do things right, and of course they can continue manufacturing and producing, but they now have to deal with the issue of making sure that they have to welcome the customs authorities to come and check their records. Would that be a preferred approach?
Yes, I mean, that's the whole essence in the first place of Fast Track, and I like the word Fast Track 2.0. So, and that will be the essence. We will be delighted to have that kind of a situation. But already, even as we have Fast Track now, there's also the issue of speed, because when those products get to when your goods get to your factory, you won't have access to them until the customs officer that is going to certify it also comes. So there shouldn't be that delay. And the burden of getting them to come shouldn't also be placed on you as a manufacturer, because it has a way of truncating your manufacturing process, your workflow. So it's important that we be able to have an arrangement that is seamless. I think that will certainly be preferred, because sometimes it takes you 2 to 3 weeks when your goods have arrived at the port for you to be able to take them out. And when you do get into the port, there are infrastructure challenges that makes it difficult for you to physically get them out of the port. So everything about getting your goods out very quickly to your factory, would help. And also, when they get to your factory, whatever the designated place is, you should be able to have access to those products for your manufacturing. Because what is really important is actually getting you to have your raw materials, your machines or your spare parts to be put to effective use in your factory.
Excellent. Okay. Thank you so much, sir. Maureen, I also want to touch on an area that I know it's something that's close to you from a logistics perspective. You deal with people, members of for Mr. Ajayi Kadri, but you also deal with people like me who are moving small things across, in our boxes. And then, of course, you also have the cargoes who are moving cargo. Because usually those ones will come under some other framework, okay, what you call your low value shipments, okay. So the NCSA now provides, for simplified customs declarations for those type of shipments, okay. While there has been uncertainty in the past about, the relevant customs procedures for those low value shipments, do you think the NCSA has adequately addressed these uncertainties? Can you shed some light of what were previous rules, what is the current requirement under the NCSA, and what is still missing? What are those uncertainties that still exist, so that people like myself, we know exactly what we will get when we have to move this small letter, a small parcel from one country to another country. Yeah, you're muted. You're muted. Still muted.
No, I think I'm. Can you hear me very well now?
Yes.
Okay.
Yes.
So thank you so very much, Chijioke. For me to answer this question, I will start to say that yes, it appears that NCSA has actually tried as much as possible, and is also a laudable one, because what they have done now is they've tried to define. They did not define it, but they tried to define it in such a way as to classify them under two categories, if we may say, categories 2 and 3 in WCO guidelines for immediate release. But it might be too long a read if I have to read it out here. I don't have it, and I'm sure Uchenna will have it and then be able to read it out for us to know the two categories. But it's worthy to state here that WCO guidelines specify that low-value shipments can come from any means of transportation. But with NCSA, they have just limited the imports to only postal or courier shipments as low-value shipments, which in quote for me, it's better than where it was before, because everybody does it based on discretion. However, it has excluded something. I think it excluded the possibility of having, there are a lot of voluminous shipment that could come in, but they have very low value.
Yeah, frozen. We've lost Maureen. Okay. All right, so maybe we can move and then come back. So, Uchenna, we're going to wait until the Q&A session before we bring you back, okay? Because there are lots of questions that most of them are directed at you. So, let's allow everyone else to share to say their own views as well while we move on and see if Maureen will come back. Right. So, Nancy, I think the last question will be, the NCSA notes talks about advanced rulings, and I've talked about it, right? This can be interpreted to mean that rulings issued are only valid for 1 year, okay? And must be revalidated to continue to remain in effect, okay? So it talks about, the rulings can only stay within the fiscal year. Given that business needs may require that the business validates its ruling every year, and may do so at a cost, that is if the NCS charges a user-based fee as provided by the Act, how do you think this will impact business willingness to obtain advanced rulings? Okay, as the service implements these provisions, do you have any recommendations for the service? How does this provision compare? Again, I'm asking you. You're trying to compare with other African countries. So subjects around advanced rulings and the validity of advanced rulings.
Okay, so the advanced ruling is a very welcome development, as in it's before it wasn't the 1958 Act was a nightmare, but this is very interesting. To be fair to the Nigerian customs, having the advanced ruling being valid for 12 months is practically, it's like common practice in Africa, because we know sometimes the product change, and once the product change, the same ruling, for example, if it's a tariff application, may be different. Valuation, we know the economics change. So looking at what's happening in Nigeria today, we know things change. However, what I believe we could do in terms of recommendation is, can the customs, if there's nothing that has changed, and let's not forget the WCO, WCO ruling is valid for 3 years, provided the facts and the conditions and the circumstances of the valuation or the ruling, the advanced ruling remains the same. So if the conditions change, the ruling you've also gotten from the WCO changes. So let's just know that in most countries, like in Kenya, in Tanzania, in Seychelles, it's 1 year. In Uganda, in Ghana, it's based on what the customs authority is at the discretion of the customs authority. However, what we can do to avoid disruption to the business. So if I get a valuation ruling and nothing has changed, the customs should implement like an online system that can quickly validate it. For example, bringing in your certificate of analysis, your MSDS, just product analysis. This product is the same thing that I imported last year, nothing changed. So for example, I'm talking about classification, then the ruling remains. So that would be easy. Then for valuation, the same thing. If nothing has changed, it's still the same price. Don't forget, we're supposed to be using the first one is the custom valuation method 1. So if nothing has changed, then we can continue to refer to the transaction price. So it should be a bit more easier. So not telling me to wait for, don't forget the process takes you to 150 days, that's 5 months. So I wait for 5 months to get a ruling that just lasts me for 1 year. So the question is the disruption to the process. So I know maybe before the end of another 5 months, I need to start preparing to renew it, which is just going to be a bit disruptive to businesses. So for the advanced ruling, I recommend they can use it through the NICES on the NICES platform. Can we have like an online process just to validate it? You can upload your previous ruling, upload your critical important documents to the ruling. It's evaluation ruling, it's on rules of origin, it's on classification. Just upload it on the NICES and it can be validated between 1 week is fine. And also another important part is when I'm seeking this valuation, this advanced ruling, we need clarity at which stage. So can it be tracked online? Can I apply for evaluation ruling? And I think the NICES platform should do more, can be configured to do more. So can I go on the NICES to say, okay, I've applied, how can I track this process? Just to give me clarity. So it helps me in planning. So if I'm a merchant, I want to import whatever product and I've applied for a ruling, it will guide me in terms of when to start my raising my Form M and everything, because the ruling gives me guidance on the duty that is applicable. So the question is there an online process? Can we, this is a recommendation like you asked for, can we have an online process, our NICES to track it? Because the NICES, there's a lot we do with NICES this day. So can we use it to track it? Can we have it something very more simplified, not complicated? And I actually think 150 days is a lot for you to get evaluation ruling, because in countries like Tanzania, in countries like Kenya, it's like 30 days. So can you?
It's not good.
Sorry.
No, continue. More is trying to connect. You can continue more, Nancy.
So can we shorten the time? 150 days, 5 months. So if I want to import, it's even going to slow down my business processes. I have to wait 5 months to get evaluation ruling. Can we get it in 30 days? Can we even get it in 2 weeks if it's a product you're already importing? So these are areas of improvement for the Nigerian customs, but all the same, like I earlier said, the valuation ruling is a welcome development. Yeah.
Excellent. So we'll take Maureen is back. We can take her comments and then we go to the Q&A very quickly. We have a number of questions, and then we'll put them together and then ask Uche to respond to all the questions that come through, which are largely directed at the Nigerian Customs Service. So Maureen, you want to take your comments now? Maureen, are you there?
Yes, I'm trying to set up. I hope I can. Okay.
No, we can hear you. You can continue talking. We can hear you.
Okay, that's fine. Let me just go ahead. Yeah, I was sorry. So sorry about that. I was thrown off completely, and I'm not sure what I was saying. So I was talking. Yes. So where did I stop, please? I was talking about the low value.
Yes, and the fact that the NCSO only limits it to postal and courier, and not all other forms of transportation.
Exactly, and this is so. What happens now is that actually excluded possibility of having voluminous shipment. Of course, that can come in through seaports or airports and everything. And when it comes in, how do we do that? That means they're no longer going to be treated as low value shipments. So those are the concerns that we have. Like I said, it is a welcome development that Section 157 of NCA has actually tried to define that and then aligning it with WCO guidelines. However, they have limited it again. So we need a lot of clarity, because if we don't have this clarity, we are also left at the discretion of custom officers that we met at the port, which means we are back to where we came from all of a sudden without aligning on this. And those are my challenges really on this one. But am I okay with it? I am okay that we have, this is one step forward, but we need to also implement that. When during implementation, we need to understand where they are coming from, how they have arrived at that. But to a reasonable extent, they need to clarify that particular act, because it is not all courier, all freight shipments or seaport shipments that have high value. You can get a shipment that is very voluminous, but the value is actually very little. So they need to tell us where and how do they determine the value of the shipment, and then what do they call low value, and what are the categories? What is the benchmark of a low value shipment? Because from what I have seen, if you look at the guideline from WCO, there are 4 categories, but they have chosen 2, which strictly is only for postal or courier shipments. So excluding all the other ones that could be low value shipment. That is that's actually my challenge there completely.
Thank you so much, Maureen. So we'll move to the Q&A session, take some of the questions, some of the points that have been raised by panelists, and then some of the questions that have been raised by our participants. Uchenna, I hope you're ready. I think that, yeah, so the ones that we skipped, the conversation around digitization. There are also comments around when are we going to have the AEO implemented? Okay, the AEO program, when is it going to be implemented? We also have questions around, the 4%, FOB charge, user based charge. Okay, so your cost of collection, okay, and 4%. I know you talked about some 7% before. Again, the conversion is that the whole 7%. Does it how does it? So can we categorize as a reduction? We also have questions around penalty provisions. So the calculation of penalties. How is it calculated now? Is it on just the difference between what you should have paid and what you should have paid and what you paid? Okay, in terms of the base. We also have questions. I think let's start with those ones first, and then if you have any one or two, we answer those questions before we close the panel session. Uche, over to you.
Thank you very much. Whoa, that's some bombardment right there. So I'll try my best to take the ones that I've noted, and if I miss out anything, you can bring me back. So first of all, let's go to digitization. I think everybody is very pressed about this issue, but I pointed out that the Act already mandates and provides for electronic processing techniques. And it would interest you to know that even sequel to the promulgation of this Act, on 30th May 2022, the Customs Service signed a concession agreement for a modernization project. So the service was already way ahead of the curve, trying to modernize its processes. Most of the things that have been talked about are things that are contained in the agreement: fast tracking, access to information on the site, amendments, inputs. So all of those are actually underway, but I'm happy that we're having the conversation, but it's certainly something that the service is considering, because I think that this is going to be more effective even for the officers themselves as opposed to manual processing. Then I'll just like to make a quick point about the clarification of the appeal process as spoken to, as referred to by Nancy. If you take a look at that section 270A, it gives a timeline within which you should receive a response. It states that it should be within 21 working days. So obviously, if the provisions of the Act is not followed, then you would be well within your right to escalate to the headquarters. It is, of course, not specifically stated within the law, but that is the expectations, and that's the reason why there are timelines. But your notes have also been taken as to specifics, and I think that these are some of the things that we would clarify in the regulations. As regards sensitization, yes, you're right. The law was just rolled out 6 months ago. I said it at the beginning of the conversation that the sensitization at the moment has been even mostly internal, because we're trying to go cascade it from, like top to bottom, to make sure that our officers first have the requisite information that they need to be able to discharge their duties before we even spread out. It's a slow but steady process, but something that is actually ongoing. Then, sorry, let me see, I had some notes. Then, yes, as regards okay, no, I think that had already been attended to. Sorry, Chidoke, can you tell me if there's...
So there's a question around the 4%, FOB, and the cost of collection. That's one. You want to address that?
Okay, yes. So obviously, the service felt that, based on cost calculations and all that, the economic things that went on, they felt that 7% cost of collection was not sufficient to finance the services operations, hence the reason for the 4% FOB. At the moment, that has not actually gone into full implementation. So the services operations are not even being financed with the 4% FOB. So as regards the private sector implementation of same, I think once the Ministry of Finance, Budget and National Planning activates the section, then that would then be transmitted across. I just remembered a point now that someone had referred to as to when they're going to the commands and some of the operations of the SEMA are still effective. I must make it known that law is not retrospective, but it commences from when it has come into actions. So any action that occurred before this law came into process is going to be treated under the SEMA. Because obviously you cannot, it's just like we talk about the stipulations of the fines and penalties and all of that. The law does not operate retroactively. So we cannot take, unfortunately, because there are the positive and the negative connotations to same, but any act that occurred before this law was promulgated will be attended to under the SEMA. Then subsequently, everything that had come forward after April that the president signed this law into act would then be attended to, subject to the provisions of the NCSA. Mr. Chidoke, sorry, please cue me again. Any other?
Maureen raised the issue around clarity on low shipments, low value shipments. There's still some uncertainty, and of course, still leaving companies like ours to the discretion of the authorities, because it's not very clear.
Okay, low value shipments is provided for in section 160 of the Act. I think she mentioned that the classification of the categories 2 and 3 in the WCO was not sufficient enough to cover all of the low shipments. I think things that they handle. But you see, this is also part of the reasons why earlier when I said that provisions were made for regulations, because once you codify into law, then you have to go through legislative process to change that law. Before these considerations were made, I said there was extensive stakeholder engagement, and I feel that the service would have seen that basically the categories 2 and 3 is what they can accommodate under the current economic system. But like I said, her point has also been duly noted, and we would see if this can be accommodated within the regulations. But I think first of all, it would be to roll out operations within categories 2 and 3 first of all, and then subsequently every other thing can also be provided for in regulations, because the service now has powers to do same, formulate same.
Okay, next question will really be around fast track 2.0, AUO. We know, so we do fast track 1.0, customs and all before the NCSC announced fast track 2.0. The NCSC has brought in the AUO scheme, and of course we know globally the AU is a lot more robust than the fast track 2.0 that I think had been initiated before the NCSC came into effect. The question now is, we have the AU in the NCSC. When will the AU come into force so that members of MAN, Mr. Ajayi Kadri's members, don't have, when they take products from the ports to the warehouse, they don't have to wait for customs 3 weeks. He mentioned 3 weeks, still waiting for customs to come before they open the container. And there are quite a number of concerns. Lots of questions around fast track and how one command operates in a certain way, another command operates in different ways. And while fast track is supposed to facilitate trade, it's currently not facilitating trade as it should be. So when are we going to have AU coming to force?
Okay, so like I said in my conclusion, that the test of the law would be in its implementation. This law has already been passed, and AEO is part of the provisions of the law. Has Mr. Ajayi tried to effect this provision and it has not been attended to? Because the law specifically even states for the procedures for the AEO application. So I would think that you should test us and put in your application for the AEO and then see what the response would be for us to then have that feedback. Because basically, if you look at sections 108 comprehensive, so basically that's what I'm just trying to say is that, like I said in response to Nancy's questions, is that once the law has come into place, come into promulgation, it is assumed to become effective. Of course, it is slowly rolling out, but in this particular circumstance, the AEO provision has been provided for, or requirements basically has been provided for by the law. So I would actually like you to test it out by trying to carry out your application, and then that would make us sit up and approach the subject.
The last question here, before we close the panel session, will be around penalty calculations and how penalty. So there are 2 issues around. We're having an issue with customs. Penalties and fines still going to be applicable while I'm resolving those issues. That's number 1. And number 2, we're still hearing traders saying that if customs adjust, for instance, the base, the value of a particular product or the freight cost, for instance, and they increase it, okay, say from $100 to $200, okay, the 100% increase, and it ends up being that you're going to pay on that freight cost in addition to value, FOB value. That customs today is still calculating penalties not on the differential 100, but on the 200 new freight cost, and so you pay your 25% on 200 and not on the difference. So those 2 issues around penalties, because penalties is very important. We have significantly increased penalties now. So we need to, everybody is now being careful around how customs imposes penalties on them. So please can you provide some clarity around how penalties should be calculated? That's number 1. And 2, what happens when you're in dispute with customs? Will penalties continue to be imposed? Remember again, I think recently terminal operators have significantly increased fees at the ports. I'm hearing almost 300% increase. So the impact of a delay, again, whether it's customs or other regulatory agencies, have a direct impact on businesses. So this is a very critical point from a facilitation perspective, and of course from a financial perspective. Please share some light there before we close the panel session.
Okay, so there are 2 facets to these penalties. Most of the penalties that have been increased in the Act are actually penalties that a person would be subject to if found liable upon conviction, which means that you have to go through a legal process. It is not at the discretion of the officers to impose those penalties on you. And then the other aspect of the penalties just has to do with the de minimis value, and that's just what's it called again? I'm sorry, my brain is frozen. That's just when they give you, when you don't pay the import, when you don't pay your import duty, and you're just giving the notice. But most of the penalties that are referred to in the Act are if a person is found liable upon conviction. These penalties are not just imposed by the service on the trader or the importer or the exporter, except for, I think the only things that there's a specific calculation for is excise duties, which the formula is provided for within the law. But most of the penalties are if a person is found liable upon conviction.
Thank you so much. Thank you so much, Uche. Ladies and gentlemen, that's as much as we can take. I think I'll just give our panelists, apart from Uche, 30 seconds, please, to just give final comments on this session, and then of course we will round up the panel session and bring this webinar to a close. So maybe I'll start with Nancy. 30 seconds, please. 30 seconds.
Thanks, thanks for inviting us here. I just hope to see more collaboration and partnership with the customs in implementing the law and more engagement opportunities. And thank you, Uchenna, and well done for the explanations you gave us. Thanks.
All right, thank you, Nancy. Mr. Ajayi Kadri?
Yes, I think I'll told the same line. Thank you for the clarifications you have given. I believe with your promise that we'll continue to engage, we'll look forward to it. Apologies that I didn't have the technology to show your background. It's like I'm the odd person out, but it's great to have had this exchange. We have a very good relationship with customs, and I'm happy to see familiar faces. Thank you for the opportunity.
And Maureen?
So thank you so very much, Uche, for all the clarification and everything. But I think I still have about 3 concerns to make here. User education, I think it is very key, internal and external, because if you get to the port, we still have the same issue. You have done the user education already, but we still have to do an in-depth internal user education and external for them to understand that the new NCSA 2 2023 is actually in place. Also, ease of communication with custom, timely responses. Unfortunately, there are a few things I would have loved to say that I couldn't say there because the questions was not thrown to me, but we need that, and we need more stakeholder engagement. Like I said earlier, digitization is the key to everything, the key to not paying fine, key to making sure that no revenue loss, key to make sure that we are able to facilitate trade. If that is done, we're not going to see anything. It's just like saying that we're extending the number of days that we have to retain documents, which I think should not be so. If we have all the things in the custom portal, we might not need all this, because whenever you need it, you go to the system and pull it out yourself. Thank you so very much for having me today.
Thank you, everyone. It's an absolute pleasure. I think we've gone overrun by about 7-8 minutes. But it's an absolute pleasure to have moderated this session. I know there are lots of questions, lots of areas that, Uche, I know you try to dodge us, you try to dribble us, but I noticed it. I know our participants also caught it, but we'll have others, we'll have sessions. But to everyone, please feel free to reach out. We will be happy to address any questions that have not been. Of course, when we require to get in touch with customs, we can also get in touch with customs. And where you think that, like Mr. Ajayi Kadri said, look, the legislation is here to stay. Fines are now quite significant. Of course, there are also benefits and concessions that have been provided. This is not the time to continue to look and be ignorant about legislation. This is the time to be proactive and ensure that we can take great benefit from this legislation as much as possible. So I will encourage everyone to look inwards, do internal reviews, look inwards, see where we can be a lot more optimal and a lot more efficient, so that this legislation is beneficial to us while we continue to engage. I know that Mr. Ajayi Kadri will not stop here. I'm sure he's already preparing his next notes, that he's going to have and have with the executive around how we can improve the NCSA. It's an absolute pleasure, and then I'll yield the floor now back to Daisy. So, thank you very much.
Thank you so much. Chijioke, for facilitating that fantastic session. Thank you so much to our panelists. Thank you for being with us. Thank you for speaking to us. Thank you for sharing insights. And thank you, Uche. Thank you so much for responding to all the questions that were raised. We're winding down. We're coming to the end of the session. It's time for us to make some announcements, which will be handled by Taiwo, a manager with the Global Trade Advisory business at Deloitte. Taiwo will give us the announcements in less than a minute. Taiwo.
Okay, thank you so much, Ada. I think that was a very insightful session. Very nice, and I am sure that we have all learned two things from here. I mean, we are far spent on time, so I'll try to be as quick as I can. So if you have any questions, I know there were several things that were asked on the call. Please feel free to send them to any of the names you can see here on your screen, and we will be happy to either refer them to the NCS or would answer those that we are actually able to take. Also, as well, for the benefit of those of us that joined the call late, right? We have prepared a news letter on the NCSA, that gives us a bit more insights, right, into the act. And we would be sharing that as well with everybody who has joined this call. So just look out for that and expect it to come into your emails sometime next week. But just to end this, I think it was a fantastic session. I want to thank everybody who joined us for this 2-hour session. I think that's it from my end. I'll be moving back. I'll be handing back the mic to Adaize. Thank you so much, guys.
Thank you, Taiwo. Thank you for sharing the announcements with us. Please note, I know there are a lot of questions around whether the slides will be shared. We would confirm with Ms. Uchenna, and it will come in together with the newsletter as well. So you want to look at your emails for that. Now we are going to take the closing remarks. Just to close out the session, and we would have Olumide Eson, who is our energy and resources leader at the firm, to give us the closing remarks. I remain your host. Thank you so much. It was such a pleasure moderating them, being an MC for this session. Bye.
Cool. Well, it's been a well-spent morning, and in the famous words of Maya Angelou, be present in all things and grateful for all things. So thank you all for being present this morning, and we are indeed grateful for your attendance. To our esteemed speaker, Ms. Uchenna Egolum, thank you so much, for the detailed presentation. And of course, distinguished panelists, I've so much enjoyed the very engaging and insightful discussion this morning. Of course, and time constraint meant that we could not fully exhaust the opportunity that we had with you today. So again, the essence of this is bringing to life the fact that this law has come to stay. I could see tremendous opportunities here to avoid fines and penalties, but also to optimize your trade transactions. That's exactly what Deloitte is built for as a partner to our clients here. Come talk to us. We are available, and we look forward to engaging you further. Thank you so much, and goodbye.
What does it really mean to be connected to nature? Let the sun kiss your face. Breathe in the wind. Feel the soil. Sink into the sand. Float in the ocean. Just be here. Because we are all connected. Let's protect these moments. Let's protect our planet. One action at a time. Better futures together. What does it really mean to be connected to nature? Let the sun kiss your face. Breathe in the wind. Feel the soil. Sink into the sand. Float in the ocean. Just be here, because we are all connected. Let's protect these moments. Let's protect our planet. One action at a time. Better futures together. What does it really mean to be connected to nature? Let the sun kiss your face. Breathe in the wind. Feel the soil. Sink into the sand. Float in the ocean. Just be here, because we are all connected. Let's protect these moments. Let's protect our planet. One action at a time. Better futures together. What does it really mean to be connected to nature? Let the sun kiss your face.